Secure Act is an important new law that affects how retirement assets pass to your heirs. And we want to make sure you understand it. I'm Stephanie McCullough of Sofia Financial. I've got Rebecca Sallen of Sallen Law Firm and Kevin Gaines of American Financial Management Group. We're all in suburban Philadelphia, and we are here to try to help you understand the Secure Act. In the law, there's different types of beneficiaries, and they have different rules about when they can spend the money. So Rebecca, could you give us an overview of what the heck a designated versus a non-designated beneficiary is?
Sure. A designated beneficiary is someone who is specifically named an individual versus an entity, a trust, your estate, a charity. We're talking about someone who's living that has a recognizable life expectancy.
So that's the designated. And then non-designated is an entity, like you said. So what's the rule around the non-designated beneficiaries to take their money out?
So if it goes to a client's estate, either because they don't have a beneficiary form properly filled out or because they actually wrote the words estate on there, it's still going to go to who they think it's going to go to. However, instead of being able to take it out over the course of 10 years, they have to take it out over the course of 5 years.
Got it. Okay. And then the Secure Act also introduces this new idea of an eligible designated beneficiary that has an exemption from this 10-year rule. They are allowed to still take it out over their lifetime. Kevin, can you just briefly tell us who those categories of people are?
Yes. So the eligible designated beneficiaries, since they can still use the stretch, it's your spouse, it's minor children, which interestingly, the minority is defined by each state. And it's your children. It's not grandchildren. It's not the neighbor's kids. It's your children. A lot of people have got that confused already. As well as if you're disabled, and there's a very strict definition for that, chronically ill. Again, strict definitions that they stipulate within this law. And interestingly, anybody who is less than 10 years younger than you are, so a sibling or a friend, they're within 10 years, they get to use their life expectancy as well. They're not confined by the 10-year rule.
So if my child inherits and they're under 18, because that's the age of majority in most states,
right,
they don't actually get lifetime, right? Tell me what happens.
Correct. So they get to use the lifetime up until the time they hit majority, and then the 10 years starts.
Okay.
So, if you inherit at 1, you get to take, 17 years worth of small distributions. But then once you hit 18, that money has to be gone by 28.
You have 10 years to take it all out. And Rebecca, we know what 18-year-olds tend to be like. What happens if 18-year-olds get a whole bunch of money?
Well, there's two scenarios I look at. One, 18-year-olds tend not to have the best financial heads on their shoulders. They are also in a time of their life where they may be figuring out what they're going to want to do, and having an influx of money can kind of distort their natural path.
Mm-hmm.
So if we all think about times in our lives where we've really grown, it's usually in times of constriction and times of lean, being like, okay, how can I make myself to get to the next level? If you're 18 and you're like, oh, great, I have $100,000 a year and it's $1 million IRA. I don't need to really pay attention in college. I really don't need to do those things. Worse, maybe you're going to surround yourself around people who are with you for the wrong reasons. They're going to be preying on you, like friends, people who want to do business with you and selling you things like that, selling you bridges that don't really exist. One of the clients that I talk to a lot, or type of clients I talk to a lot, are people who are single parents, and they know that they want their children to inherit their money. However, they are very concerned that if they are not around, if their ex, the child's parent, is going to be leaning on them for these distributions, and how uncomfortable it would have to be the child to really say no to their mother or father. So giving it to an 18-year-old is not a good idea in, I would say, most circumstances.
So we've been focusing so much on retirement accounts because that's what the Secure Act addresses. But most people have other assets as well, right? So You've perhaps got a house that you've acquired over the years. You've perhaps got other investments that are not in retirement accounts. These things pass differently according to your will, most likely, and then they are taxed differently upon your passing. So one of my recommendations to people is to kind of get a good sense, a lineup of what your different assets are and understand how they pass to your heirs, and then kind of line up on this side all the various people and entities you would like money to go to. And then it might be time to make some adjustments on which pieces are going to whom.
That's a great advice to give your clients. Absolutely.
One point about Roth, because Roth IRAs, Roth 401ks, Roth 403bs are not taxed when you take them out at retirement. They were taxed at the time of contribution. So if you are leaving a Roth IRA to someone, they don't have the tax issue so much, but that IRA still does have to be vacated in the 10 years if they don't have that eligible designated beneficiary status. Kevin, do you have some thoughts on other strategies, other things people might think about in the face of the Secure Act?
Yeah, really because of this accelerated distribution now, making sure that you have the non-designated beneficiaries. They really want that IRA at this point because they don't care about tax rates by and large. If you're talking charities and things along those lines.
So it's super efficient to leave retirement money to charities.
Correct. And, they're just going to take it immediately anyway, most likely. They're not, so the 5 or 10 year rules don't, not that they have 10 year rules, really impact them. So you're not inconveniencing them. From a planner, when I'm talking with people, I'm also talking to people who are going to be beneficiaries, encouraging them to talk to their parents about this because you don't necessarily want to inherit this money. The conversations we have, we're planning distribution strategies. And, an extra $1 million is nice in theory, but that's going to change a lot of things, if you're in your 50s, 60s years old.
Right. So if I inherit a retirement account from my parents, all of a sudden I have this requirement to take income in years when I might not want income. Maybe I've got kids applying to college, applying for financial aid, and all of a sudden I have this income. It can affect other taxation and other issues. It can affect my health insurance premiums. There's all kinds of stuff.
Yeah, if you're older now, Medicare, Social Security, taxability, and things along those lines as well. So, there's this 20-year period where you really want to know ahead of time what type of money you're going to be dealing with.
So it's back to the old message that we say all the time, right? Talk about these things with your family. Talk about the money stuff. It can be uncomfortable to bring it up. It can be uncomfortable for everybody. And yet it's so much better to have that knowledge up front, to make informed decisions, because in a crisis, that's never a good time to all of a sudden have an unpleasant surprise. I think, again, just to reinforce to everybody, this is educational. This is not advice for your specific situation. Please get in touch with your professionals, accountants, estate planning attorneys, financial planners. We'll have our contact information below if you're interested in reaching out to us. We'd be happy to talk to you. Thanks so much for joining us.